Good morning to all of you. Video number 1440. This video is specially for the law of taught students. Friends, in the last class, we discussed the capacity to file torts. Now we are going to other chapter called as defenses or general defenses in the tort law or exceptions to the torts. So in IPC, you might have heard exceptions will come first, general exceptions, right from section 76 to 106 IPC. Of course, up to 98 only, 99 to 106 will be regarding the personal safety, right of property. But anyway, they are all exceptions, right from 76 to 106 IPC. Exceptions will be there. That means even though a crime is committed, this man can take the exception. That means he need not be prosecuted. No doubt, crime is a crime. Don't be under wrong impression that a child below 7 years cannot commit a murder. He commits a murder, it's a murder. But he cannot be prosecuted because of the general exception. Likewise, there are certain exceptions to the torts. They are called as general defenses. So, as advocates, you have to know the defenses first, because don't expect that people like Rama, Krishna or so many Buddha, these people will approach you. No, definitely they will not come. So the other people, which we can example, Ravana, Kishika, these people will come to you and you have to defend them. No doubt, it is for the court to decide whether they have done the mistake, whether they can be convicted or acquitted. It's a different thing. But as far as possible, when a case is arrayed against your accused, definitely you have to defend him. So defenses are more important. That's why even in criminal cases, now as far as the tort law cases are concerned, you have to learn the defenses. There are 12 types of defenses. 12 types of defenses. So all of them cannot be told in one video, but I will make them one by one. So the first one let us discuss for today. So overall, so the first one is VNFI, that is volunteer non-fit injuria, that is voluntarily accepting the injury, knowingly going to the place. In Telugu we call it చీమల పుట్టలో చేయి పెడతాం. చీమల పుట్టలో చేయి పెడితే ఏమవుతుంది? కరవకుండా ఊరుకుంటాయి. డెఫినెట్లీ ఎందుకు కరిచావు చీమ అంటే చీమ డెఫినెట్లీ విల్ రిప్లై సమాధానం, నా పొట్టలో ఎందుకు పెట్టావు అందుకని కలిచాను, అందుకని పొట్టలో వేలు పెట్టి కరిచింది అంటారు. దట్ మీన్స్ you are willing voluntarily. So you cannot say that it is a tort. Second is plaintiff, the wrongdoer. You yourself committed tort, yourself is responsible for the tort, and you say that tort is committed. No, it will not be accepted. Then comes, ఇది చాలా ఇంపార్టెంట్, inevitable accident. Means even though you all take precaution, you take all types of precautions, something will be done, then you can't be held responsible. Number 4, mismeasure or act of God. You might have seen the film Gopala Gopala. There the insurance company, how many clauses they will give. So this is act of God, which is totally unexpected. Then right of prerogative. Just now I told you, right from section 99 to 106 IPC. So in execution of right of defense, definitely you can cause a tort and it will be a very good defense for you. Then mistake sometimes will lead to exception. Then necessity, you all know, necessity knows no law. At times of necessity, definitely you can do some tort and it will be accepted. Then statutory authority, already I told you, article 361 or sovereign immunity, I can tell you. So statutory authority, the law says something. Suppose if the violent mob surges forward against the other group and the police in between, he fires at the crowd and one person dies. Yes, it is regarding statutory authority. Yes, they can do it. So that is it. So even though they commit a tort, that means if the police lathi charge you, normally if the reasons are good under statutory authority, you cannot file a case of tort. Then judicial acts. So the judicial officer, at times he may say, come on, you arrest this fellow. Yes, the judicial officer is competent. So if it is backed by the so-called statute or judiciary article, when you read the article 50, it will be known to you. So doctrine of separation of powers. So judiciary, definitely they have got immunity. You cannot file a case of tort against judiciary without permission from the concerned authorities. Then Parental and quasi-parental authority. This also it seems to be funny because if the headmaster asks you to come with particular uniform, yes, he has got parental authority. You cannot file a case of tort. At the time comes, I will tell you, a girl, she has filed a case against the parents that they are asking her to do cooking and to learn driving and also not to use the cell phone. Court said no, it cannot be a tort. Then dilatory defense. This is a prolonged defense. This is not that much necessary for you. And last one is contributory negligence. It is a big chapter. Anyway, we'll discuss all of them time bound. Now we'll confine with volunty non-fit injuria. Volunty means voluntarily. Injury is caused due to your voluntary act. It is not fit to be a tort. So simply VNFI, voluntary non-fit injuria. So please remember, so here you are actually causing the damage, you are getting the damage by self-consent, by and you are getting the damage, then you cannot file a case against them normally. Please remember in this connection I wanted, people used to go to see the cricket matches, they want to go see the car races, they will go to the hockey matches and they will go to the horse races also. And they want to sit in the front side. They want to sit and enjoy the movement of the horses, enjoy all these things. But they know that if the horses gallop and if they actually run on them or if they tread on them, definitely they will get injury. But still they invite it. Best example is Jallikattu. Jallikattu, yes, you are encouraging. It is nothing but a replica of a bullfight in Spain. People encourage it, people good. If you get injury, then you cannot get any compensation. Likewise, I will give a best example. Philip Hughes, I think he is an Australian batsman. So, while playing in the cricket ground, the bowler, Mr. Abbott, I think, Cian Abbott, the bowler Cian Abbott, so he has bowled very perfectly, very speedily, due to which the ball hit him on his head, and actually this incident happened on 25/11/2014, and immediately since it hit him, I think here the injury was caused due to cerebral hemorrhage, he died. So who is going to pay compensation? Maybe the government, but the bowler need not pay compensation because it is voluntary non-fit injuria. There is no tort because it is a ground where people will definitely receive injuries. There are a couple of case laws that is more important for you, not this all this story. These stories are only just examples, but case laws are important. You have to cite the case law. Very famous case law is Bird versus Hall. This is Hall versus Brookland Auto Racing Club. Hall versus Brookland Auto Racing Club, 1933. So Mr. Hall went to the so-called racing club. That is, he wanted to say the car races, not horse race, car races. So he went there, he was enjoying happily. Actually, that was in a diamond shape, or in Telugu we call it as a badam shape. In badam shape, the ground was there, and they have erected fencing, and all beyond the fencing also, they have actually left a space of about 6 feet around in that oval shape itself. They have developed a greenery, they have taken all precautions. But incidentally, so that is an accident. What is the accident is which we do not expect. So this man has gone there, he stood in the front row, he was enjoying the auto races. Incidentally, there was a collision between the cars. And one of the cars actually flied over. It has flown over the other side, ultimately came up to this hall and injured him. He received injuries. Then he filed a case of tort, since due to the negligence of the auto racing club, this incident happened like that. He has filed a case, but the court did not agree. Because the defendant, who is defendant? The race club owner. They could prove that they have taken all precautions, and this man voluntarily went there. He stood in the first row and he wanted to climb the so-called fencing. He was actually climbing, I think he might have climbed the fencing, whatever it is. Since they have taken all precautions and this man volunteered to go to the club, to go and occupy the front seat, definitely they are not liable to pay any damages. This is taken as an exception, as the car rammed into the gallery. The car, so they did not expect. So this is a voluntary non-fit injuria. And the second case, this is also. So this is Woolrich versus Summer, 1963. Woolrich versus Summer. Woolrich was a photographer. Actually, he is a professional photographer. Summer Corporation, they are maintaining the horse races. Actually, this photographer went to the horse racing of the Summer Corporation and he wanted to take the photos. Actually, he was busy with the photos. Actually, they have given a pedestal for the taking of the photos. They have arranged a pedestal also. But this man, out of anxiety, he stood on the edge of the pedestal and he was taking photos. At that time, the horse galloped. It was going at high fast and actually this man was frightened. He was under the impression that the horse is going to hit him. That too, he was in the edge of the pedestal. He fell down and received injuries. He filed a case but not accepted. Why? Because he himself volunteered. As he stood at the pedestal or at the center of the pedestal, the incident would not have. He invited the trouble. Therefore, definitely this is not applicable. So with these two cases, let us stop here. Already 11 minutes over. I think we will discuss the other exceptions one by one. Thank you very much.